So once again, welcome to part 4 of the Public Procurement and Asset Disposal Act of 2015. My name is Judith Kwamboka, your convener for the 8-week study challenge. Today we are going to look at part 4 of the Act. And part 4 talks about powers to ensure compliance. Part 4 is composed of sections 34 to 43. And just as an opening remark, the National Treasury has given the powers to ensure compliance with the Public Procurement and Asset Disposal Act to the Public Procurement Regulatory Authority, to the authority. So from time to time, the National Treasury or the authority may request for information from PEs. So it is expected that the procurement entities will provide this information as shall be required, as may be required by the National Treasury or PPRA. But in most cases, PPRA acts on behalf of National Treasury to ensure adherence to the Act and all other procurement policies that have been issued from time to time. So with this in mind, PPRA will carry out investigations if a need has arose within a reasonable time. They will examine the procurement records of a public entity. They may also look at the records that are owned by the contractor, the supplier, or the consultant to determine whether there has been a breach in the procurement process. So the process of investigation is initiated by PPRA upon a request by a public institution or by any other person who has an interest in the said procurement. Once they have received that request to carry out an investigation, the authority appoints an investigator. It's not that the whole office comes there, they appoint someone to handle that case. And what is the investigator supposed to do? As you are going through the Act, Section 36 talks about the responsibilities of an investigator. If you have been appointed to go and carry out the investigation, what happens? And that is if you're an employee of PPRA. So with prior notification to the procuring entity, the investigator shall have access to all relevant premises, books, records, returns, reports, and other documents of the procuring entity or a person who participated in the procurement or asset disposal proceedings, including electronic documents. So you can refer to Section 36 to get the roles of an investigator. Why is it important for you as a procurement person to know the roles of an investigator? So that when PPRA has sent investigators to your institution, you are not bullied around. You're able to know the boundaries, what this guy or this lady should ask for from you, what they can do and what they can't do. If you're ignorant, then you will be panicking and you'll be taken advantage of. Then we move to Section 37. It talks about the report of investigation. After completing the investigation, an investigator shall prepare and submit a report to the authority. Section 38 talks about what the Director General of the authority does once he has received the report. He will go through the report and what can he do under Section 38, if he's satisfied that indeed there was a breach, he can direct the procuring entity to take such action as are necessary to rectify the contraventions. He may terminate the procurement or asset disposal proceedings, may prepare and submit a summary of the investigator findings and recommendations to the relevant authorities for action. For example, he or she can forward it to EACC for further investigation. Then he may require the procuring entity to transfer procuring responsibilities of the subject procurement to another procuring entity. So So that is very gross. So those are some of the potential outcomes of an investigation done by the authority. Then before those orders mentioned in section 38 are made, the procuring entity is given an opportunity to make presentations. Before making an order, the Director General shall give the following persons an opportunity to make presentations: the PE and any other person whose legal rights the Director General believes may be adversely affected by the order. So it's not do or die. So once the authority is satisfied that there was a breach, they will give you an opportunity. They will inform you of the breaches they have seen. Then they will give you an opportunity to come and defend yourself before an order mentioned in section 38, subsection 1, before any of them is made. Then, if the PE or the person who is affected by those orders is not satisfied, he has a right to request for judicial review at the High Court, and this has to be done within 14 days from the time the Director General made that order. So that is in section 39. Then we go to section 40. Section 40, I didn't mention about it. Now, just note that no investigation if issue is before the review board. Like, someone cannot jump to High Court before the authority has finalized its investigations. Like the moment a complaint is registered and an investigation starts, the procuring entity or whoever is aggrieved rushes to High Court. That is not permitted as per section 40. Then section 41, we talk about debarment. What is debarment? Debarment is when an entity, a business entity or an individual is prohibited from doing business with government through public procurement or asset disposal processes. A supplier, a contractor, an individual consultant is prohibited from participating in any procurement or asset disposal proceedings. So section 41 gives us conditions under which an entity can be barred. Number one is if they have committed an offense under this act, committed an offense relating to procurement under other act or law of Kenya, has breached a contract procurement by public entity, including poor performance, has in procurement or asset disposal proceeding given false information about his or her qualifications, has refused to enter into a written contract. You've gone through the procurement process, then you've got to contracting and this person declines your offer. That is one of the things which can qualify someone from being debarred. Has breached code of ethics, has defaulted on his or her tax obligations, is guilty of corruption or fraudulent practices, is guilty of a serious violation of fair employment laws and practices. So those are the conditions under which a supplier can be debarred. And just for your noting that you as a procurement person, you have a big role in this because it is you who will inform, for example, the authority that this person gave us false information. This person refused to enter into contract. So, and when a firm is prohibited or debarred from participation, it should be a period of not less than 3 years. So section 43, section 42 actually, a party to debarment may seek judicial review from the decision of the authority to the High Court within 14 days. So just like the other scenario of procurement investigations, the firm which has been debarred can go to High Court within 14 days after they receive the notification that they have been debarred. Section 43 talks about inspections, assessments, and reviews relating to contracts, procurement, and asset disposal proceedings. So you're given the how, you're given more details on how the inspections and the assessments and reviews relating to contracts, procurement, and asset disposal proceedings are carried out. So take your time, refer to that and the relating regulation on the same. And that brings us to the end of part 4. Thank you so much. See you in part 5 on internal organization of the procuring entities.